Welcome back. I'm Carissa Kranz, and there you heard it. Those key words. I did it. I did it. It's a prosecution witness, and this witness is David Rangel, and he is the cousin of the defendant, and he is speaking about a phone conversation that happened back decades ago. With me, Jean Rossi, attorney. I want to give you the opportunity to give me some of your legal expert opinion on that testimony that we just heard, which is quite significant under the circumstances.
Absolutely. Whenever the prosecution calls a family member that has inculpatory bad evidence against the defendant, that is incredibly powerful. Mm-hmm. And this cousin, Mr. Rangel, when he said that the defendant stated, "I did it," unless you can somehow show that's a joke, that's an incredible confession.
Yep, I think we're having some technical difficulties listening to you, but it sounds like you're saying that it was pretty detrimental because we have an admission and a confession through a family member. So hopefully you have good sound now. How can the defendant come back from this?
Well, on cross-examination, what the defense attorney has to do is bring back that this was April of 1993. It's 25 years ago. The defendant, the witness had to be refreshed with a statement that was taken about that time. So you have to attack the memory of the witness. And the other thing is this: was it said in jest? Was it just, were they joking around? He said they were shooting the breeze. I find it hard to believe that the defendant's just going to say to his cousin, "I did it," without any, segue or anything like that. So that would be the purpose of my cross. The memory, it's old, and that what were the circumstances? Was it sort of just shooting the breeze and a joke? That's the best you can do.
Right. So let's continue with David Rangel's testimony to see how the jurors may take the context of this confession/admission to the cousin. Let's go back to court. Welcome back. I'm Carissa Kranz, and you are listening to testimony of David Rangel, the cousin of the defendant, David Villegas. And he is saying on the stand, which is helping the prosecution's case, that the defendant made a confession to him, which is on a written statement that is decades old. And as you can see here, he has to keep referring to the statement to refresh his recollection on the facts of what was actually said. With me, Jean Rossi. Let's talk about this for a minute. Is this believable that he did it? Or is this more of a lack of credibility in the prosecution's case because his memory is so unclear and inconsistent, and he's got to keep reviewing a statement to remember something that you would think you'd never forget?
You brought up a good point. When your cousin tells you that he murdered two people and he says, "I did it," you really don't need a report to refresh your recollection. That would be my closing statement. If this really happened, that 1993 conversation would be seared, etched in his memory, and you wouldn't need to know. I do have to critique the prosecutor a little bit. This witness was horribly prepped.
Mm-hmm. I agree.
You can't prep a witness to say, "I did it," without looking at a piece of paper.
But it's possible that he was prepped by the prosecution, but he doesn't really want to testify for the prosecution. So he's admitting to what he wrote so he doesn't perjure himself, but he might really be for the defense. We'll see what happens on cross.
Carissa, I got to say, this cousin did not look like someone who was unwilling to testify against the defendant. It's not that he wanted to, but he was willing to say exactly what the defendant said to him. But it goes back to prep. If, given the result in this case, I'd like to talk to the jury and see what they thought of this cousin's testimony, because it was not prepared properly, and it was meandering. There were notes. It was terrible.
You bring up a good point. You'd like to talk to the jury. After we saw, which we played on the network a little while ago, the explosive verdict. After that explosive verdict, which had incredible energy in the courtroom, which we will replay again for you on the network in a little while, you want to know, what did the juries think? Because they actually did deliberate a while. Like, how did they feel when that verdict was read and watching the emotion of the defendant? Did that change anything for them? I mean, it's different listening to the defendant versus listening to other witnesses on the stand testifying for either side. That's the screen right there where you see him crying as the verdict is being read. He's literally brought to his knees. We will have to go to a quick break, but after the break, we will replay this for you again because it just is such an explosive verdict, and we rarely see these moments in a courtroom live, and we will replay that here on the network for you. Stick with us. Welcome back. I'm Carissa Kranz, and that was some key cross-examination we just heard. That is the defendant's cousin, David Rangel. So on the prosecution spent their time bolstering their case, saying he admitted to killing. And now, after the statement of "I did it" on cross-examination, you heard the cousin say, "I didn't take him seriously. He made up stuff all the time. He liked to get credit for things he didn't do, to be more macho," basically. With me, Gene Rossi. What do you make of this?
I think this is horrible, Carissa.
Right? It's a defense case right now.
First off, I got to give an A+ to the cross-examination.
I agree.
He got out exactly what he wanted. If this defendant is a 16-year-old kid who embellishes, he exaggerates, no one takes him seriously.
And he didn't even believe it. It wasn't only did he take him seriously, did he take him seriously, and did he believe it? And the answer was no to both.
Yeah, but Carissa, I got to tell you this. I believe that the defendant may have said, "Hey, I did it. I saw the guy. We exchanged glances. I went back and I shot him." Okay? And he was probably joking about that. And the prosecutor, here's the thing, Carissa. If the prosecutor knew this was going to come out on cross, she should have fronted it and brought it out during direct exam to take the sting away. This is awful.
I agree. There was a whole reveal on cross-examination, which the prosecution could have taken away the reveal and the suspense, but it was a slam dunk for the defense in that case. Seriously, a slam dunk. Okay. Anything else you want to add before we go into the next phase of this trial?
No, what I think of a balloon, nice, beautiful birthday balloon, and somebody takes a little pin and goes poof. That's what happened.
Right. I agree. I mean, we're listening to this. This is a prosecution witness. And as you said before, the prosecution could have done a better job prepping their witness. Not only that, they could have probably done a better job prepping their case, knowing, because you know they knew that information. There's depositions before trials. You know that this information must have been known on some level, that he didn't even really believe his cousin. He didn't know whether to take him seriously. He made up stuff all the time. This is what he did. This is what kids do. So... But he did say, "I did it," and that was written in a statement. Anyway, we're going to continue following this trial. Now let's go to closing arguments, the prosecution's closing arguments in particular. Let's go back to court. Welcome back. I'm Carissa Kranz, and that is prosecution's closing argument in the Villegas trial. And if I'm hearing this correctly, Gene, what I just heard was that the entire prosecution's closing arguments case is hinging on David Rangel's testimony of the confession he heard from his cousin, which he admitted on cross-examination he didn't believe himself, which the prosecution just said in closing arguments that he did believe, even though the evidence revealed in trial says otherwise, that he's flat out said on cross-examination, "I didn't believe it. I thought he was joking." I mean, those questions were directly asked and answered, and the prosecution just flipped it in closing arguments, basically hinging the entire case on their main lead, David Rangel, to clinch the defendant Villegas. Am I missing something here?
No, Carissa, you hit on 2 points. Number one, the prosecution, if they have to rely just on David Rangel, it's a loser, but they added insult to injury, and here's how. When a prosecutor especially, or a defense attorney too, says something in closing that is so contrary to what the jury heard, the jury completely tunes them out. And that's sort of like the Van Dyke case. The video showed 16 bullets going into a body, and then the defendant's on the stand saying, I didn't mean it. You know, they're trying to fit a square peg in a round hole. It was painful to watch the prosecution's description of Rangel and stating that he believed it. He didn't believe it. He thought his cousin was a total BSer, period.
I know, period. That's right. It's just period. You have to end there. Like, how did the prosecution bring this up in closing arguments and lie? I mean, that's a lie. We heard it from his mouth, and closing arguments is not testimony. That is not facts and evidence. It is directly in contradiction with facts and evidence, which is testimony. If the jurors remember that, which I hope, I can't wait to listen to closing arguments of the defense to see if they call the prosecution out on this, and if the prosecution even has a rebuttal to this. But that is a major error, and you're right, they will lose all credibility if the jurors picked up on it.
And if the defense does, I assume this was not rebuttal. If the defense does not say in their closing, you know, what the prosecutor just said is flat out wrong. The prosecutor misstated the evidence.
Misstated the evidence. That's the best phrase today.
Yeah, Carissa, what I would do is I would say, let me read you the transcript of Mr. Rangel.
Yep.
And that would just, and I would turn to the prosecutor. What the prosecutor did was wrong.
What fireworks in this courtroom, and wait until we replay that explosive verdict. We have to take a quick break. Stick with us. We will be back for some more closing arguments and then that verdict. We'll be right back. Welcome back. I'm Carissa Kranz, and this is the American justice system at play for real. And you'll see what I mean when we replay this verdict in the courtroom. It is quite explosive. I've never seen anything like it myself. This defense attorney is doing a very good job in closing arguments, not only poking holes in the case, giving reasonable doubt, but then he does an incredible job of giving the jurors the responsibility that they hold in that deliberation room. He is telling them to hold on to their moral compass, and he is putting on the whiteboard, as he reiterates, reasonable doubt requires you to be certain, fairness requires you to be sure, and justice requires you to be right and to stick to your instincts when you go into that deliberation room. That is some powerful testimony. With me, G and Rossi, I want to give you the opportunity to comment on this closing argument versus what we heard before the break, the prosecution's closing argument, and how you would think the jurors are going if you didn't know the outcome of the case.
First off, let's talk about his demeanor. The defense attorney has a very believable and sincere presentation and style. And he's not talking down to the jury. That's number one. Number two, showing the instructions, basically, of exactly what reasonable doubt is. That's the second good point. The third good point is this. As you just said, Carissa, he's giving them little nuggets of reasonable doubt because they have to eliminate all reasonable doubt, not just one nugget. And he's given them ID. He's given them coercion and terrorizing a witness. And the third one he gave at the beginning is, okay, you're having this bullet analyzed in June of this year? What the heck have you guys been doing for 25 years?
Exactly.
He's getting into sloppiness. So he's giving them some nuggets that they can hold on to when they go into that deliberation room and make arguments for innocence.
Okay, so like as a side, because the prosecution must have known this going into this. They didn't have the confession to use. They couldn't use the jailhouse calls. They know that the bullet is being looked into and analyzed so many years later. Why didn't they plea this out?
Oh, why
They
didn't
could
they?
have secured a conviction. They could have done a time served plea.
I can tell you exactly why, Carissa. I was a prosecutor for 27 years. When you have a murder, and this is a double homicide, they will retry this case 7 times if they're able to. They will very rarely drop a case, of a double murder.
I know. I was a prosecutor as well, but I probably would have gone to the bosses of the bosses of the bosses and said, look, I don't think we can prove this case. If we want to secure a conviction, I think it would be better strategically to offer them a time-served plea rather than them, because you still don't know what the court is going to do or the judge is going to do. It's always a gamble, and you would have had a conviction. But who knows what happened? We have to take a quick break. Stick with us. We'll be right back. Welcome back. I'm Carissa Kranz. That's Prosecution's rebuttal argument. With me, legal expert Gene Rossi. What do you make of this so far? We've watched the prosecution closing, the defense closing. Now we're on the rebuttal. Give us some legal expert insight.
Well, here's the thing. It goes back to what we were talking about before, Carissa. Mm-hmm. If you're relying on this, alleged confession that he made to his cousin 10 days or a week after the alleged killing by him, and that's all you really have, then you probably should go to your supervisor and supervisor and say, we can't bring this case and do it a third time. We don't have anything. And I got to bring up something. There's a famous Supreme Court case called Smith from, I think, 1948. And it's a famous case where it says that if you have an uncorroborated confession, that is not enough to find somebody guilty. And in this case, we essentially have a classic uncorroborated confession, if you will, without any forensics, without any eyewitness. And I think the jury realized that without even having read the Supreme Court case.
Right.
This is not a good thing. And I got to say this, the prosecutor is doing the best she can do with nothing.
Right. She is doing a good job. Her tone is good. Her demeanor is good. I agree with that. And also, I think what you bring up right there about an uncorroborated confession, what's different this time around versus the last trial where they secured a conviction, because remember, this is his third trial, is the last trial when they secured a conviction, his confession was played. But it wasn't played in this trial because it was determined on appeal after he's been in jail for 18 years that he had a claim of innocence, that confession was forced, and he had ineffective assistance of counsel. So this time around, you're right, it is completely uncorroborated. And another thing to point out is he was 16 years old at the time. Kids and teenagers all the time like to seem cool and buck up in stories in order to seem much more macho to their friends. And even his cousin said, I didn't really believe him. He made up stuff all the time.
Absolutely. And he could have made up stuff all the time about other violent acts. Who knows? I robbed a 7-Eleven. We don't know that.
Right.
That's possible.
Let's go to the key moment we've all been waiting for, and that is when the verdict is read. This one is a really special moment. Let's take a look. It's always nice to see justice like that happen in the courtroom, and sometimes justice really does happen. Gene Rossi, I want to give you a final thought before we have to sign off for the day. We have less than a minute.
That verdict made me proud to be an American.
Right? I know. It really is a proud moment. Because
the jury applied the law to the facts as they saw it, and that man, he had to, it was very emotional. It was a very great moment.
I have the goosebumps just watching it. We do need to sign off for the day, so thanks, Gene, for joining us. We appreciate your legal expert analysis, as always. And for those of us watching, this was the Villegas trial out of Texas. It was a 1993 case. He stood trial a third time. The first time was a mistrial hung jury. The second time was a conviction. After he spent 18 years behind bars, it was overturned on appeal for ineffective assistance of counsel, a claim of innocence, and a forced confession. His family stood by his side, and now he is a free man. That's a wrap. See you tomorrow.